and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Consumer Protection Bill 2018. The bill sets up a mechanism to investigate consumer complaints and prescribe compensation to the consumer. It also imposes a jail term of up to 2 years and rupees 10 lakhs as fine for manufacturers making false and misleading claims in advertisements. To discuss the issue, I have with me Jayashree Gupta, cyber law expert and also a lawyer, Supreme Court, and Mrs. Jayashree Gupta, President, Consumers India. But before we get into a discussion, let's have a look at what all is there in the proposed legislation. The Consumer Protection Law was made in 1986 to provide for better protection of the interests of consumers and to establish consumer protection councils for settlement of consumer disputes. The government feels the working of the consumer dispute redressal agencies have served the purpose to a great extent, but disposal of cases has not been fast due to various constraints. Consumer markets for goods and services have undergone drastic transformation in the last 3 decades. The emergence of global supply chains, rise in international trade, and the rapid development of e-commerce have led to new delivery systems for goods and services and have provided new options and opportunities for consumers. Equally, this has rendered the consumer vulnerable to new forms of unfair trade and unethical business practices. Misleading advertisements, telemarketing, multi-level marketing, direct selling and e-commerce pose new challenges to consumer protection and need swift executive interventions to prevent consumer troubles.
You see, the Central Consumer Protection Authority has been visualized based on the previous experiences, that the consumers were able to go for redressal only after they have incurred a loss or a damage, or unfair trade practice has been committed. But the authority will now look into, the mandate will be, look into all issues which can lead towards violation of the consumer rights, or lead towards ensuring that we have a good environment in terms of consumer protection. So the authority will have suo moto kind of a mandate where they can take cognizance of certain issues which would harm the consumer, and they can go ahead to give directives to the manufacturers or to the service providers or to the importers not to deal on such products or such services.
The Consumer Protection Bill 2018 provides for the establishment of an executive agency to be known as the Central Consumer Protection Authority, CCPA, to promote, protect and enforce the rights of consumers. It will deal with matters related to violation of consumer rights, unfair trade practices and misleading advertisements. The CCPA will have an investigation wing headed by a Director General which may conduct inquiry and investigations of violations. The CCPA has been empowered to inquire into violations of consumer rights, investigating and launch prosecution. It will have powers to recall goods or withdraw services that are hazardous, reimbursements of the price paid, and discontinuation of the unfair trade practices. It will be able to issue directions to the concerned entity to either discontinue a false or misleading advertisement or modify it. It will be able to impose penalties and issue safety notices to consumers against dangerous or unsafe goods and services. The bill also details 6 consumer rights, which include the right to be protected against marketing of goods and services which are hazardous to life and property. Be informed of the quality, quantity, potency, purity, standard and price of goods or services. Be assured of access to a variety of goods or services at competitive prices, and seek redressal against unfair or restrictive trade practices.
The law itself is really a path-breaking one, and I would say that's because for the first time the law has provided for a regulatory mechanism to actually enforce the rights of consumers. Let me just explain this. In the 1986 Consumer Protection Act, it enumerated the 6 rights of consumers. However, it provided for enforcement of just one one right, that is a right to redress of grievances. As far as other rights 5 rights were concerned, it left its enforcement to toothless advisory bodies called the Consumer Protection Councils. So what it meant was consumers could go to the consumer courts constituted under the law for violation of the rights, but there was no regulatory body to prevent those violations. As a result, consumers were, at the receiving end of lots of, bad marketing practices.
The Consumer Protection Bill 2018 was introduced in Lok Sabha by the Minister of Consumer Affairs, Food and Public Distribution, Ram Vilas Paswan, on January 5, 2018. The bill replaces the Consumer Protection Act 1986. A Consumer Protection Bill to replace the Act was introduced in 2015 but has been withdrawn after the introduction of the latest 2018 bill. With Amritanshu and Nishta Malhotra, Raj Sabha TV. So one of its kind regulatory authority for the consumer protection. Immense powers to the CCPA to protect, promote, enforce. 3 words with immense powers and responsibilities. So that's where I come to you, Virag. On the e-commerce front, that's the new area where the consumers are most threatened as of now. So that's where the misleading happens. That's where the products don't get delivered, the products that the consumer requires. That has been included in the ambit of this bill. How do you see it working out?
Now the consumer protection is in the concurrent list. It being enforced by the state government as well as by the central government. Now this IT Act provision is exclusive in the central government domain. No action can be taken without the IT ministry or the central government authorities. Now IT Act is 2 decades old, and in that there is not enough provisions or explanations are made regarding the e-commerce. Now corresponding changes are to be made in IT Act and other places which are not being done along with this act. Secondly, when the e-commerce has yet not been defined, second aspect comes about your jurisdiction to enforce the laws against those companies who are mostly foreign companies. They are doing business in India, but they are outside purview of your jurisdiction. We have seen that in that blue whale challenge, the whole government machinery, high courts, supreme courts, state government and the central government failed to control or regulate the menace of this blue whale. So tomorrow if some misleading advertisement is there in the internet, in spite of the repeated directions of the Supreme Court, government failed to stop the pornography. This is a type of right of violation of the common people. So how will you, number one, stop the misleading advertisements in the internet which are not directly in your jurisdiction? Secondly, how will you stop the e-commerce, because those companies are calling themselves as the intermediaries. So they are basically marketing the product in their name, but when the liability comes, they are not taking that. And third thing important,
they have been included by definition in this entire bill, and that is how this bill is actually novel, new.
I fully agree. This is a historical bill. This is a very revolutionary bill, and intention of the bill is to protect the interest of the consumers. What I am saying, to give the proper relief to the consumers, we need 3 things. Number 1, that the change in this court mechanism. Number 2 is the corresponding changes in the other acts. Number 3, coordination with the state government so that it should not become like the RERA.
I'll come back to you to understand all the 3 points better, but let me get Mrs. Gupta in. Ms. Gupta, on the misleading part and the product aspect, do you see the concerns of the consumer being actually addressed in this bill?
Yes, I agree that this is a very path-breaking legislation for Indian consumers. We in Consumers India have been raising our voice about the need to bring about a Central Consumer Protection Authority on the lines of Federal Trade Commission of USA and Product Safety Commission in USA for a long time. And I'm very happy that this bill has been introduced. My only wish is that it sees the light of the day without further discussion further, because initial bill was introduced in 2015, then it has gone through the rigmarole of it has gone through the rigmarole of being referred to in the standing committee. It has stood the test of that scrutiny, and I'm sure this 2018 bill addresses the concerns raised by honorable members of the standing committee. So now it should be passed in this session of parliament.
And so you want relief for the consumers at the earliest.
At the earliest.
And that is what you're struggling for.
Yes, that's what I am struggling for.
So as the whole bill as it stands is a pretty path-breaking one, but the two aspects that you mentioned, the federal laws on the US federal laws on products and misleading advertisement, has that been included? Have those aspects?
They have been included. They have been included, though it's not as strong as the provisions in those acts, US acts are. But something is better than nothing, and we have to see how it goes. I'm sure there would be tremendous scope for bringing about future amendments. So it should not be withheld or go through any further discussion because it can be made better. Right. For example, I'll give you an example. In USA, Product Safety Commission asked Reebok shoes to substantiate their particular ad, which they thought is misleading consumers. When a Reebok shoes company could not substantiate those ads, they imposed a fine of $25 million on Reebok shoes. So that has a kind of deterrent effect, not only on that company,
but kind of punishment is not here.
Is not here.
Yeah, that kind of deterrent is not here.
That kind of deterrent is not here.
Yeah.
But even this 10 lakh, this power is there with, is not there with under the existing laws.
Right, right.
So even, recently I saw an example, let me share with you. Ban on plastic bags.
Correct.
It has been there for a long time. There is a fruit wala in my colony. He used to give plastic bags right and left all the time, and everyone, you come empty-handed, take fruits and vegetables in his plastic bags and go away. To hell with law. Recently, a fine of 5,000 only was imposed on him, and that changed his practice. He stopped altogether. So I feel that even if celebrities
are given some deterrent, they will stop arbitrarily.
Even this 10 lakh fine, if it is imposed on a celebrity for misleading consumers,
it will do its job.
It will do the job in a big way.
Virag, on the enforcement side, you were making three very important points, which I kind of we switched over to from. So the enforcement part, and being a lawyer yourself and having practiced in these theaters several times, how do you see the law being really enforced, even if it is passed quickly, the way ma'am wants it to?
Ma'am was saying, I will add only 2 points, then I will come to those 3 points.
Yeah.
Number one important point is made in this new law is the class action suit, and the second is the product liability action. Now, if the class action suit comes, then there is scope of huge penalty as being imposed in the Europe and the USA.
Correct.
Now, coming point from the enforcement, because people don't want law, they want justice. If there is any cheating is there, something is there. Now, we have existing some 4,20,000 pending cases in the different consumer courts. Now, how this situation will change? Because again, you have to go to the same places. 6 years back, I approached the consumer ministry and asked them, what is, you have the system of the complaint redressal mechanism. They don't have any team, they don't have any person. Now, this investigation wing, how powerful and the big this team will be to handle all such type of cases. Now, if the pendency is there, then the people have tendency not to go and lodge their complaint. Now, there are three main problems are there. Whenever any law is made, the adjudication is mainly done by the judicial officers. They automatically adopt the practice of the civil procedure code. Now, that civil procedure code is 100 years back old. These laws are there, filing the application, then filing reply, then rejoinder, then what's the procedure is there. It takes time. Now, the second is evidence. Now, we have seen the FSSI model where they don't have sufficient laboratories. So, we don't have the sufficient laboratory, then how will you give the evidences? Now, this second problem. Then consumer courts are mainly in the model that consumer should directly go. But because of these complicated models, it has become the lawyer's paradise. Now, the fourth important point is that you have made provision for penalty against the misleading advertisement against the manufacturer, but why should there not be provision for penalty against the adjudicating authority for not making the decisions within the stipulated time limit as per the law?
So no, no timelines have been prescribed.
Yes, no, even if timeline is there, even if timeline is there, what
Yeah,
I'm saying,
the
execution of it.
if no, in the earlier law also there was timeline. What I'm saying, in all the laws, in the latest all the laws, timelines are there. What I'm saying, that the person who is adjudicating the matter, he should also be imposed penalty if he fails to decide the matter within that time limit. It should be his obligation.
Fantastic points made by you, Virag. But the most important, the earlier consumer protection law was designed in a way so as to allow the consumer to directly reach out to the courts and take relief, whatever he wanted. That role will be minimized once this bill replaces that or becomes a law. So the direct interface of the consumer going to the court without a lawyer and seeking relief may not happen the way it has been happening. Coming up, it's time for us to head into a break. When we come back, we will tell you how the bill prescribes tough punishment and brings into ambit stars endorsing products. Welcome back. The Consumer Protection Bill 2018 imposes maximum of 50 lakh rupees fine and maximum imprisonment up to 5 years if there is a repeat offence involved. This punishment can be meted out to manufacturers or service provider for defective goods or services. Even an endorser can be fined or restrained from endorsing a product or service if it is found to be misleading. The Consumer Protection Bill 2018 provides for the establishment of an executive agency to be known as the Central Consumer Protection Authority, CCPA. This fills an institutional gap which is there in the present regulatory framework. Currently, the task of prevention and taking action against unfair trade practices is not vested in any authority. This has been provided for in a manner that the role of the CCPA complements that of other agencies so that duplication and potential conflict is avoided. The bill also has provisions for mediation as an alternate dispute resolution mechanism.
You see, in our country, the law of tort is not very active. So, what this would bring in is that if any product, like for example, you sell a, say, knee implant to a patient, where the knee is being replaced, the joints is being replaced by a device, which is either imported or manufactured in the country. So anything which becomes defective in terms of the product, the liability will be there on the manufacturer. The manufacturer has to ensure that they take all the cost, which will incur by patients or by consumers in terms of that product.
The Consumer Protection Bill 2018 empowers the CCPA to impose penalty on a manufacturer or anyone endorsing the product of up to 10 lakh rupees for false and misleading advertisements. In case of a repeat offence, the fine may go up to 50 lakh rupees. The manufacturer can also be punished with imprisonment of up to 2 years, which may extend to 5 years for every subsequent offence. The CCPA can also prohibit the endorser of a misleading advertisement from endorsing that particular product for a period of up to 1 year. For every subsequent offence, the period of prohibition may go up to 3 years. The bill also sets up Consumer Dispute Redressal Commissions, CDRCs. They will be set up at the district, state and national levels. A consumer can file a complaint with CDRCs in relation to unfair or restrictive trade practices, defective goods or services, overcharging or deceptive charging, and the offering of goods or services for sale which may be hazardous to life and safety.
इनमें सबसे पहले तो है कि सेंट्रल कंज्यूमर प्रोटेक्शन अथॉरिटी एक रेगुलेटरी अथॉरिटी के रूप में नियुक्त की जा रही है, जो मार्केट्स में जो अनुचित प्रथाएं चल रही हैं या जो गड़बड़ हो रही है उसको रोकने के लिए स्वयं एक्शन ले। क्योंकि आज की तारीख में हर कंज्यूमर ये काम अपने आप नहीं कर सकता, और वो तभी करता है जब उसके फ़ायदे की बात हो, और कभी करता है और कभी नहीं करता। तो उसके कारण से मार्केट में कई सारी ऐसी प्रैक्टिसेस हैं जो आम कंज्यूमर्स को नुकसान पहुंचाती है। उनको रोकने के लिए कोई अथॉरिटी होनी चाहिए, और ये अथॉरिटी जो बना रहे हैं इसका हम स्वागत करते हैं। दूसरा जो है, इसमें आजकल कचहरियों में कई साल लग जाते हैं झगड़े में, और उसमें अपील में और अपील पर अपील में। तो इसमें एक प्रावधान है मीडिएशन का, कि हर कंज्यूमर कचहरी में एक मीडिएशन सेंटर बनाया जा रहा है, जहां पर मुकदमे सुलह सफाई या मीडिएशन के थ्रू अगर सॉल्व होते हैं तो उनकी कोशिश की जाएगी। ये स्वागत योग्य है। और तीसरा स्वागत योग्य है कि जो जुरिस्डिक्शन है, अगर आप आज घूमने गए हुए हैं और आपने किसी दूसरे शहर में कुछ की चीज़ खरीदी या कॉन्ट्रैक्ट किया और वहाँ पर कुछ गड़बड़ हो गई आपके साथ, तो आपको मुकदमा फाइल करने के लिए दूसरे शहर में जाना पड़ेगा। पर इस नए कानून में उन्होंने प्रावधान रखा है कि आप वहाँ भी केस फाइल कर सकते हैं जहाँ पर आप रहते हैं या काम करते हैं। ये इसकी हम स्वागत करते हैं, क्योंकि कंज्यूमर्स के ऊपर जो भार है वो थोड़ा कम हो जाएगा।
The district CDRC will hear complaints where value of goods and services does not exceed 1 crore rupees. The state CDRC will hear complaints valued at 1 crore rupees but does not exceed 10 crore rupees. Complaints with value of goods and services over 10 crore rupees can be heard by the national CDRC. In order to prove liability of a product on the manufacturer, service provider or seller for compensation, a consumer has to prove the defect or deficiency as mentioned in the bill. With Nishtha Malhotra, Amritanshu Rai, Rajya Sabha TV. The bill brings into its ambit for the first time endorsers. So all superstars and stars and the faces that are there in the entertainment industry who are constantly endorsing shoes to needles to houses to almost everything, all of them will now be under the scrutiny of this law once it happens, and can be taken up or pulled up for misleading consumers if there are evidences. Ma'am, the point you were making about how the small little thing, a small little change in this entire legislation, allowing the consumer to file a case where he lives and not where the incident occurred. Yes. So that is a huge benefit for the consumer, which will prevent him from actually traveling all the way. So how do you see that? That's a very small but significant.
That is very, very important. And another important part is e-filing. The bill permits electronic filing of complaints. So this is also in keeping with the changing times, because particularly our young people, they want to do everything. They buy shoes and socks also online. So we cannot expect them to stand in queues and make several visits to consumer forum. So I am sure with the increase in financial pecuniary ceilings, district forums, we expect district commissions would be more vibrant, and state commissions will basically be the appellate authorities. And
do you see the punishments and the fines as deterrent enough?
There will be a big progress, big move forward from the current scenario. But as I said, it does not compare with the powers that Federal Trade Commission, etc. have in the USA and other countries.
But then we are still developing.
But still, as I told you, even 5,000 rupees fine made a big impact. So 10 lakh, if the thrust is to implement it, to set this authority in place and start taking action. The authority should consist of people who are really, work with missionary zeal.
Right.
And who do not, who are not into too much of bureaucratic system, and who really want to make a difference for consumers. And
provide relief to them.
Since this authority is permitted to take suo motu action for safeguarding interests of consumers, I feel that lot of burden on consumer forums would come down. because instead of consumers approaching that this glass of water, tea which I had ordered has a fly in it, this restaurant is not working well, or this mobile has this problem, we expect that this authority, if there are complaints by large number of consumers, the authority can take suo motu action.
The point you were making, Virag, on the manufacturing part.
Before coming to manufacturing,
Yeah,
let
quickly.
me complete that celebrity aspect. There are two aspects by which they will escape from their liability. First, they will say that what action you are taking against the newspaper on that advertisement is there. Number two, they will say that I am endorsing only the product. I am not endorsing any mischief or any some misleading thing. So in that, they will try to escape because they are the big people, they have the good lawyers. Now coming to the manufacturers. Now you have booked a Uber car. So Uber taking credit of each and everything, but once car some liability is there, then they will say we are only aggregator. If you have any problem, go to and sue that car driver only. You have done anything. Suppose you have booked a hotel through Make My Trip. So Make My Trip will, whenever any problem is there, they have booked, they have taken the payment, they have taken everything. But once any problem is there, they will say, no, we are only aggregator. If you have any problem, and sue that hotel, and hotel will say that I don't have any contract with you.
Virag, you will allow lawyers to twist any simple law. You people have the fertility to twist and turn, put the laws upside down. That is there available with you, and I give it to you. But the reality is that for a start, for a consuming nation that we are,
In the digital
do you
India,
see a good start?
in the digital India, why don't you make exhaustive provisions for these digital companies? That is my complaint.
Okay.
Now my main problem is all the internet companies, their website is based in USA, their financial companies based in Ireland, and their only marketing companies based in India. Now those all collectively sell product in India. Whenever any problem is there, this Indian company will say, I am not concerned. And how will you enforce law against the US companies? For that, my only request is make necessary provisions in this new bill.
Right. So just trying to gather the entire thing and put it together. So the bill not only allows the CCPA to have suo motu rights, which means on its own it can call for any information, ads, seize, and can immediately act on it. So that's an important power there. Also to educate consumers. So now they have the mandate to educate and inform the consumers also that, see, this, if you don't know that this is what is supposed to be not there in the product, then know it. So that is also a big thrust that has been a responsibility provided on them. Third, also to sensitize, Virag. I know you will twist it and bring it down, but these three, four points, that's a major advancement for the consumers' rights. So thank you, Virag and ma'am, for joining us on this discussion. It's time for us to end the show. You can watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.